In 2020, a judge quietly ruled that Nick Reiner was so mentally unwell he couldn't care for himself. Then 1 year later, the system let him go, and everything that followed would explode into a Hollywood legal crisis no one saw coming. This story matters because it exposes the moment where mental health systems, criminal justice, and celebrity media collide, and once they collide, there is no rewind button. The revelation that Nick Reiner was placed under a court-ordered mental health conservatorship in 2020 fundamentally reframes everything the public thinks it knows about this case. Not as gossip, not as rumor, but as a documented legal reality, quietly confirmed through court clerks and national reporting. A licensed fiduciary was appointed. A judge found grave disability. Those words are not symbolic. They are legal thresholds. They mean the state concluded Nick Reiner could not provide himself with food, clothing, or shelter due to mental illness. That's not a casual intervention. It's one of the most severe psychiatric determinations California law allows. And yet, 1 year later, the conservatorship expired. No extension, no renewal, no public explanation. Just a legal door opening again, and Nick Reiner stepping back into the world. The timing matters, because conservatorship don't exist in a vacuum. In California, this specific type known as an LPS conservatorship is rare. Most people who enter the mental health system never reach this level of state control. It begins with involuntary psychiatric hospitalization. Doctors observe behavior severe enough to justify removing autonomy. Then the Office of the Public Guardian builds a case. A judge signs off. Medical decisions are taken out of the individual's hands. Psychiatric medication is monitored. This isn't about profit, power, or celebrity control, like the Britney Spears case that permanently altered how the public hears the word conservatorship. This is about dysfunction so extreme that the system intervenes to keep someone alive. And that's where the contradiction begins. Because according to multiple sources who spoke anonymously to the New York Times, Nick Reiner had long struggled with schizophrenia and schizoaffective disorder. He battled addiction. He cycled through medications. And crucially, those medications reportedly changed just weeks before the alleged crimes that would later define this case. The earlier medication was described as effective, but the side effects, weight gain, instability, dissatisfaction led to a switch. A switch that, according to reporting, occurred roughly a month before everything collapsed. Erased the rehook most people miss. If the system believed he was gravely disabled in 2020, what changed in 2021? Because either the conservatorship worked and stabilized him enough to return autonomy, or it failed to anticipate the long-term risk. Both interpretations carry consequences. One suggests recovery. The other suggests abandonment. And neither sits comfortably beside the outcome that followed. This is the first fault line in the story. And it's one the defense, the prosecution, and the public will all be forced to confront whether they want to or not. The most dangerous part of this case isn't what we know. It's what's being revealed slowly, piece by piece, through anonymous sources and careful legal language. According to reporting, Nick Reiner's medication regimen was altered shortly before the killings. The implication is delicate, but unmistakable. His previous medication reportedly managed symptoms effectively. The new one? That's where uncertainty enters. Side effects, adjustment periods, psychological destabilization. These aren't fringe concepts, they're realities psychiatrists openly discuss. But when medication changes intersect with criminal acts, the conversation becomes radioactive. Because here's the legal contradiction: the same system that once declared Nick Reiner unable to meet basic survival needs later allowed him to self-manage complex psychiatric treatment. That shift isn't just medical, it's legal. A judge's earlier finding of grave disability doesn't disappear simply because a calendar page turns. It expires procedurally, yes, but the underlying diagnosis doesn't evaporate. And that's why sources speaking to the New York Times emphasize that his struggles intensified in the weeks leading up to the crime. That detail isn't accidental. It's context. And context, in court, is everything. This is where the case quietly pivots from criminal act to constitutional debate. Because American law does not punish illness, it punishes intent. That distinction is foundational. If someone cannot understand the nature or consequences of their actions due to severe mental illness, The legal system is obligated to pause. Not excuse. Pause. And evaluate. That's not sympathy, that's jurisprudence. And that's exactly where the defense narrative begins to form, even before it's formally stated. Hey, race the rehook. If medication played a role, who bears responsibility? The individual? The doctors? The system that approved release? The state that ended the conservatorship? These questions aren't theoretical. They are precisely the questions juries are instructed to wrestle with in cases involving mental incapacity. And yet, the public conversation often skips ahead to verdicts before the evidence is even fully assembled. What makes this moment especially volatile is how much of Nick Reiner's medical history is now circulating despite confidentiality laws meant to prevent exactly this. Multiple unnamed sources have spoken, details have leaked, and each revelation raises another question: who benefits from these disclosures, and why now? Alan Jackson did not enter this story quietly, and he did not exit it cleanly either. When his name became attached to the Nick Reiner case, it immediately changed the gravity of the legal conversation. Jackson is not a background defense attorney. He is known for his command of constitutional law, for his refusal to frame cases around emotion, and for his willingness to defend principles even when the optics are hostile. And that distinction matters, because from the moment he began speaking publicly, carefully, strategically, but unmistakably, the narrative around Nick Reiner began to shift in a way that had nothing to do with facts being introduced in court and everything to do with ideas being planted in public consciousness. Jackson's media appearances were not accidental. They were measured. On the surface, he avoided direct commentary on Nick Reiner himself, repeatedly invoking attorney-client privilege and confidentiality. But beneath that restraint was a deeper argument unfolding in plain sight, one about the justice system itself. On Kelly Ripa's podcast, Jackson articulated a worldview that startled listeners not because it was radical, but because it was brutally consistent. He rejected the very concept of an indefensible case. Not rhetorically, philosophically. In his view, defense work is not about proving innocence or conceding guilt. It is about ensuring the government meets its burden perfectly. That word, perfectly, is where everything sharpened. Jackson described the removal of liberty as an almost unthinkable act, one that demands absolute procedural precision. Not adequacy, not reasonableness, perfection. And while he insisted he was not speaking about Nick Reiner specifically, the timing made such separation nearly impossible. Because this was not an abstract lecture on constitutional theory. This was happening in the shadow of a case already entangled with mental illness, medication changes, and a prior judicial finding of grave disability. Jackson then introduced an analogy that quietly reframed the entire case without ever naming it. He spoke about epileptic seizures, about loss of consciousness, about tragic outcomes that occur without intent. In those scenarios, he argued, the law does not punish because punishment requires awareness, control, and understanding. The analogy was devastatingly effective precisely because it avoided sensationalism. It invited the audience to accept a premise before realizing its implication. If illness removes intent, then criminal culpability becomes unstable. Not eliminated, but contested. This is where the rehook deepens. Because Jackson wasn't just talking to podcast listeners. He was talking to future jurors, future commentators, and future analysts who would now struggle to unhear the framework he introduced. Once intent is questioned, every action becomes subject to reinterpretation. And once reinterpretation begins, certainty dissolves. Yet the most consequential moment didn't come during an interview. It came afterward. Quietly. Abruptly. Alan Jackson withdrew from the case. No detailed explanation. No transition period. No public handoff beyond a statement that something interfered with his team's ability to continue representation. He emphasized confidentiality. He asked the public not to speculate. But in a case already surrounded by unanswered questions, that request landed hollow. Because in high-profile legal battles, absence is not neutral. It creates a vacuum, and vacuums get filled. Almost immediately, rumors began circulating. Some suggested financial disagreements. Others hinted at strategic conflicts. Still others whispered about the difficulty of representing Nick Reiner himself. None of these claims were confirmed. And that, too, became part of the story. Because when facts disappear, perception takes over. And perception, once formed, is nearly impossible to dislodge. What made Jackson's withdrawal even more controversial was its timing relative to his media presence. From the family's perspective, according to sources close to them, this felt like betrayal. They reportedly believed that while Jackson was no longer representing Nick Reiner, he was still shaping the public narrative around him. Appearing on Billy Bush's podcast, discussing constitutional theory in ways that inevitably echoed the contours of the case. Speaking broadly, but not neutrally, the family's frustration was not rooted in opposition to defense rights. It was rooted in exposure. They wanted the process to unfold inside a courtroom, governed by evidence and procedure. Instead, they watched as philosophical arguments about justice, illness, and intent played out in the media arguments that could influence perception long before a jury was ever seated. And erased the contradiction that refuses to resolve Jackson's comments were legally correct. Everyone deserves counsel. The Constitution applies equally, even to those accused of the most disturbing acts. The justice system is not designed to satisfy public outrage. It is designed to test government power. Jackson never denied that. But correctness does not equal consequence-free. When those principles are aired publicly in an ongoing case, they stop being abstract. They become narrative weapons. This is the line many believe was crossed not legally, but ethically. When does constitutional advocacy become preconditioning? When does defending a system morph into shaping an outcome? These questions do not accuse. They linger. And they matter because the courtroom is not sealed off from the world. Jurors live in that world. They absorb its conversations. They carry its assumptions with them, whether consciously or not. Jackson himself seemed aware of this tension. He repeatedly emphasized that he does not care whether a client is guilty or innocent, that he cares only whether the government gets it right. To some, this was admirable honesty. To others, it was chilling indifference. But either way, it underscored something critical. The Nick Reiner case was no longer being discussed as a singular act. It was being positioned as a referendum on how the justice system handles mental illness. And then Jackson was gone. That absence now hangs over the case like a shadow. Because without him, the ideas he introduced remain unanswered, unchallenged, and unresolved. The public defender who stepped in inherits not just a client, but a narrative already half-constructed in the public mind. A narrative where illness, intent, and state responsibility are already intertwined. The most unsettling rehook of all is this: did Jackson leave because his job was done? Not legally, but narratively? Had the framework already been set? Or did he leave because the case became too complicated, too constrained, too resistant to the clean constitutional arguments he prefers? We don't know. And that uncertainty is now baked into the story. Because Alan Jackson didn't just defend Nick Reiner for a time. He altered how the case will be understood long after his name disappears from the filings. When the noise fades, the podcasts, the legal philosophy, the outrage, the speculation, what remains at the center of the Nick Reiner case is not a single decision, but a sequence of institutional choices that now appear impossible to separate from the outcome. This is the point in the story where responsibility becomes diffuse, where no one actor holds the full weight of what happened, and where the system itself becomes the most important character in the narrative. Because before there were attorneys, before there were interviews, before there was public shock, there was a judge, a diagnosis, and a legal finding that Nick Reiner could not safely exist on his own. That finding was not symbolic. In California, an LPS conservatorship is among the most extreme interventions the state can impose on an adult. It is not granted lightly. It requires medical testimony, documented psychiatric history, and a judicial conclusion that the individual is gravely disabled, unable to provide basic necessities due to mental illness. This designation does not hinge on inconvenience or temporary instability. It reflects sustained dysfunction. It means professionals believe the risk was not hypothetical. It was present. And yet, that conservatorship ended. By law, LPS conservatorship are limited to 1 year unless renewed. Renewal requires evidence that the grave disability persists. In Nick Reiner's case, the conservatorship expired without extension. There was no public statement, no recorded explanation, no transparent justification offered to the public. Procedurally, That is not unusual. Substantively, it is devastatingly important. Because once the conservatorship ended, the state effectively returned autonomy and with it, responsibility to Nick Reiner. This is where the case becomes uncomfortable because both sides of the argument are legally plausible. One interpretation is that the system worked, that treatment stabilized him, that symptoms were managed, that professionals determined he was capable of self-care. In this version, autonomy was restored appropriately, in accordance with civil liberties and due process. Mental illness, in this framing, is not a life sentence of state control. Recovery, improvement, and managed independence are the goals. The other interpretation is darker, that the system did not have the resources, patience, or foresight to maintain oversight, that the threshold for continued intervention is so high and the cost so significant that release becomes the default, that the expiration of the conservatorship did not reflect wellness, but procedural exhaustion. If this interpretation is true, then the system didn't just step back, it stepped away. And here is the rehook that refuses to be ignored. Which interpretation aligns with what followed? Because after the conservatorship ended, the record suggests instability did not vanish. Medication adjustments occurred. Addiction history remained relevant. According to people familiar with his condition, symptoms intensified in the weeks before the alleged crimes. These details matter because they challenge the assumption that legal autonomy equals functional stability. They suggest a gap between what the law permits and what reality delivers. This gap is not unique to Nick Reiner. It is structural. Mental health systems are built on thresholds: grave disability, imminent danger, lack of capacity. Fall just below those thresholds, and intervention dissolves. But human behavior does not follow legal definitions cleanly. Illness does not switch off because a calendar changes. Stability is not binary. And yet, the law often treats it that way. This is where the case becomes less about blame and more about design. The system did not act maliciously. It followed statutes. It respected civil liberties. It avoided indefinite control. All of those are virtues. But virtues can still produce tragic outcomes when applied rigidly to fluid human conditions. Now, consider how this reality intersects with criminal law. If the state previously declared Nick Reiner gravely disabled, that declaration will inevitably surface in court. It complicates the prosecution's narrative of intent. But if the state later deemed him competent enough to live independently, that determination will also be weaponized to argue responsibility, awareness, and accountability. Both findings exist. Both are real, and they pull in opposite directions. This duality places the legal system in an impossible position. To argue incapacity is to question the validity of the conservatorship expiration. To argue capacity is to minimize the severity of the original diagnosis. Either way, the system must now defend itself against its own record, and the public is left watching a slow-motion reckoning with no clean resolution. Because if the system failed Nick Reiner, then it failed the victims as well. But if the system acted appropriately at every stage, then the outcome becomes something far more disturbing: a reminder that even correct processes cannot guarantee safety. Another rehook emerges here. Quieter but heavier: what is the purpose of intervention if it cannot extend far enough to prevent collapse, but cannot be extended without violating rights? This is not a question courts can easily answer. It is not a question juries are trained to resolve. And yet, this case forces it into the open. The implications stretch beyond this single trial. Because if the state had renewed the conservatorship, critics would likely have decried overreach. They would have raised alarms about autonomy, freedom, and indefinite control. If the state had imposed stricter supervision post-release, questions of surveillance and discrimination would follow. Every option carries ethical cost. This is why the Nick Reiner case feels unresolved even before a verdict. It exposes the limits of institutional competence. It reveals how systems designed to protect can also retreat. And it forces a confrontation with a reality most people prefer to ignore: that mental health crises do not always present clear, legally actionable warning signs until it is too late. The final and most haunting rehook lies in a single unanswered question, one that no courtroom testimony can fully address. If the conservatorship had been renewed, even briefly, would any of this have happened? And if the answer is unknowable, What does that say about the confidence we place in systems that must decide when to step in and when to step back? That question will follow this case long after filings are archived and headlines fade. Because the system did not simply observe the events that unfolded. It was part of the timeline. And now, like everyone else watching, it must live with what came next. The Nick Reiner case is no longer just a criminal proceeding. It's a mirror held up to multiple systems at once: mental health care, criminal law, media ethics, and celebrity culture. Each system did something it was designed to do. And yet, together, they produced an outcome no one can neatly explain. A judge once ruled Nick Reiner gravely disabled. A year later, that ruling expired. Doctors adjusted medications. Lawyers debated intent. A defense attorney stepped into the spotlight, then stepped away. A family asked for silence and instead watched the story grow louder. None of these actions are inherently malicious. None are obviously corrupt. And yet, the sum of them feels unresolved. That's what makes this case so unsettling. Not because it invites outrage, but because it resists closure. Every explanation creates a contradiction. Every new fact reframes the last one. And the closer the public gets to certainty, the more fragile that certainty becomes. Was Nick Reiner failed by the system or accurately assessed by it? Was the conservatorship a protective success or a temporary pause before disaster? Did medication changes matter, or are they being overemphasized because we're desperate for a cause? Did Alan Jackson speak out of principle or ambition? And most importantly, can a legal system built on intent truly account for minds that don't operate within stable intention at all? These questions won't be answered quickly, and maybe they shouldn't be, because this isn't a story that fits into headlines or hashtags. It's a slow-burning legal and ethical reckoning, one that will unfold in courtrooms, not comment sections. And long after verdicts are rendered, one question will still linger in the background, unanswered and uncomfortable. When the system decided Nick Reiner was well enough to be free, was it right, or was it simply done? If you want to stay with this story as it continues to unfold, consider subscribing so you don't miss what comes next.